Hello, good afternoon. Today's topic of discussion is Administration of Justice in Calcutta. So let's discuss introduction. The English company's settlement at Calcutta was quite different from that of Surat, Madras and Bombay. Calcutta is one of the populated metropolitan cities in India. It was established by the English people and was named as Calcutta. It was founded in the year 1690 on the bank of river Hooghly. As usual, the company provided for the establishment of a factory for spices at Calcutta. It was a fortified factory and the fort was named as Fort William. The area of Bengal was under the control of Mughal emperor at that time. The company applied for zamindari rights of Calcutta, Sultanati and Govindpur of Govindpur. So these were the three villages and the company secured zamindari rights from the Mughal emperor of these three villages. So the Mughal emperor granted the zamindari rights to the company and thereby the company became zamindar of these three villages on which the modern Calcutta has developed or grown up. Thus, the settlement at Calcutta differs from other settlement at Surat, Bombay and Madras. In this case, zamindari rights were granted by the emperor himself. So for the first time, the zamindari rights were granted to the foreigners. The Charter of 1661 provided for raising the status of agency to that of presidency town. So thus, the status of Calcutta agency came to be elevated or raised to the presidency town in the year 1699. Thus, the Calcutta presidency became a part of the British Empire. This provided historical event as the grant of zamindari rights empowered first time a foreign company to exercise all those powers which the native zamindars were authorized to have. Thus, the company became zamindars of these three villages and those times zamindars were responsible for the collection of land revenue. The company took full advantage of the authority and appointed a collector to control the administration of all these three villages. The zamindars were authorized to have under the Mughal administrative and judicial system. In other words, the company exercised all those powers which the other zamindars in the country enjoyed and exercised. So they exercised both civil and criminal jurisdiction. A collector who was company's officer, he was appointed at Calcutta and who was also a member of Calcutta Council. So let's discuss judicial and administrative setup under the Mughal emperor. The system under Mughal Empire consisted of two parts, Nawabi and Diwani. So Nawabi was headed over by Nawab. So he was principal in charge of Nawabi, whereas Diwani headed over by Diwan and he was another principal in charge of Diwani. Nawab was responsible for the criminal administration of justice and Diwani was responsible for civil cases and the matters connected with lands in the Mughal Empire. There, the Diwani area was further divided into zamindari. Land under the emperor were divided into various allottees. The allottees are the person to whom land or shares is allotted and the person to whom the land were allotted they were called as zamindars. So zamindars were required to hold such lands subject to the payment of revenue to the emperor. So zamindars, they used to collect revenue, and he had to make payment to the emperor. So they were required to maintain law and order situation in their territorial limit or in their respective territory. In Bengal region, judicial setup in Bengal region under the Mughal emperor. In Bengal region, the judicial setup provided for three-tier system. First one was village panchayat, second court of Kazi, and the third one was chief Kazi. The system provided for the civil cases to be decided by these various courts, that is the courts of village panchayat, court of Kazi and chief Kazi. For the decision against the village panchayat, an appeal could be taken to the Kazi, and against the decision against the Kazi, an appeal could be taken to the chief Kazi. So here we have completed civil administration under the Mughal emperor. Let's discuss criminal administration of justice. And for criminal administration of justice, there were the court of Moffisil Nizamat Adalat and Sadar Nizamat Adalat. In Moffisil Nizamat Adalat, judges were Kazi, Mufti and Molvis. Principal criminal court was called as Sadar Nizamat Adalat, and it was at Murshidabad. The Nawab was in charge of the criminal administration of justice. So, the Sadar Diwani Adalat was headed by Nawab. The Fauzdar was responsible for the maintenance of peace in the society, and he was assisted by Kotwal. So Muslim law was applied by the court. The company judicial system at Calcutta under the company, and we are going to discuss the functions of the collector. So the company acquired the zamindari rights and thereby became zamindar. A member was added to the Council of Governor at Calcutta, and such additional member he was called as collector. In other words, company appointed a collector to control the administration of all these three villages. So collector, he began regularly to hold zamindari court for both civil and criminal cases. So let's discuss justice in criminal cases under the company. To administer justice in criminal cases, the company decided to adopt the existing Mughal pattern. Fauzdari court presided by an English collector, and he was established to decide criminal cases of the natives of the three villages, that was Govindpur, Sultanati and Calcutta. The manner of trials for criminal cases. Number one, criminal trials were conducted in a speedy manner. Second, they used to decide the criminal cases summarily. Summarily means without much formality. Means they used to decide cases speedily and summarily. Generally, the criminals were punished by whipping, imposing fines, imprisonment, banishment or work on road. Whipping means फटके मारणे किंवा चापकाने मारणे, and banishment means exilment म्हणजे हद्दपार. So in those days death was executed by whipping to death and not by hanging to death. म्हणजे इतकं मारलं जायचं की मरेपर्यंत त्याला मारलं जायचं. So that was the system. Jurisdiction of the court. The court had jurisdiction over the natives, that is Indians, as well as the Europeans, And in case of Europeans, they used to take cognizance of petty crimes committed by English people only. For serious crimes, the governor and council were authorized to try by the Charter of 1661. Appeals against decision of this court could be preferred to court of governor in council. So here, criminal administration of justice is completed under the company. So let's discuss justice or civil administration of justice. To deal with civil litigation, the collector presided over a civil court or the court of Kacheri. So this court was known as court of Kacheri. The collector decided cases in a summary way on the basis of the prevailing customs and usages of the country. In the absence of such native customs, the cases was decided according to natural justice and equity. म्हणजे समतेच्या न्यायाप्रमाणे the cases used to be decided. In rare important cases, only appeals were allowed to the governor and council. So this must be noted that only in rare important cases for civil appeals were allowed to the governor and council. The collector in the capacity of zamindar was also responsible for the collection of land revenue from the natives of these three villages. So whipping was the most common punishment which was given by the collector for the defaulters of the land revenue. Revenue म्हणजे शेतसारा. Appeals were made to the governor and council. So thus to conclude, in the judicial system of Calcutta, the office of collector became very important office. He was dealing with civil, criminal and revenue matters. Means here there was concentration of power in one hand, that is in the collector. He was also used to try and decide civil and criminal cases concerning Europeans in India. The governor and council were also empowered to decide serious criminal cases and important civil cases. So all judicial and executive powers were exercised by the collector and the governor and council. Means here there was corruption, there was concentration of power in one hand. They used to look after administrative function as well as judicial function also. They were not trained in law. There was no proper accountability of the judges, and hence corruption was the consequences of all these. So it created conflict and confusion that resulted in dissatisfaction. So in order to improve the existing system, the Charter of 1726 introduced new reforms in the judicial system and established a mayor's court and the court of governor in council in Calcutta. So the Charter of 1726 laid the foundation of an important area in the history of evolution of the judicial system in Calcutta. So with this, I have completed administration of justice in Calcutta. Thank you.